Senate will please come to order. Begin today with a moment of silence in lieu of a devotional. Thank you. We'll begin with announcements. Are there any announcements? The senator from Caledonia is recognized.
Thank you, Madam President. I move the Committee on Institutions be relieved of S71, an act relating to applying Vermont prevailing wages to school construction projects, and that the bill be referred to the Committee on Economic Development, Housing, and General Affairs.
Thank you, Senator. The senator from Caledonia has moved that the Committee on Institutions be relieved of S71 and that the bill be referred to the Committee on Economic Development, Housing, and General Affairs. Are you ready for the question? And if so, please unmute. All those in favor signify by saying aye.
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 Those opposed, nay. You've adopted the motion, and the bill is referred to the Committee on Economic Development, Housing, and General Affairs. Are there any additional announcements? The senator from Caledonia.
Thank you, Madam President. I move the Committee on Institutions be relieved of S73, an act relating to allowing probation and parole officers to carry firearms while on duty, and that the bill be committed to the Committee on Government Operations.
Thank you, Senator. The senator from Caledonia has further moved that S73 be referred to the Committee on Government Operations. Are you ready for the question? So please unmute. All those in favor signify by saying aye.
Aye. Aye.
Those opposed, nay. You've adopted the motion, and S73 is referred to the Committee on Government Operations. Are there any additional announcements? The chair, on behalf of the Committee on Committees, has the following committee announcements, or appointments rather. First, to the Green Mountain Care Board Nominating Committee, Senators Pearson and Lyons. To the Government Accountability Committee, Senators White, Collimore, Perchlik, and Rahm. To the Task Force on the Future of Revitalizing the Dairy Industry, Senators Starr and Brock. To the Governor's Snowmobile Council, Senator Kitchell. And this concludes the announcement on behalf of the Committee on Committees. We have bills for introduction today. First, S82, an act relating to providing the state auditor with access to accountable care organization records, introduced by Senator Polina and others. Please listen to the first reading of the bill.
S82, an act relating to providing the state auditor with access to accountable care organization records.
You've heard the first reading, and the bill is referred to the Committee on Health and Welfare. S83, an act relating to the Dairy Industry Stabilization Program, introduced by Senator Ingalls. Please listen to the first reading.
S83, an act relating to the Dairy Industry Stabilization Program.
You've heard the first reading, and the bill is referred to the Committee on Agriculture. S84, an act relating to the use of exclusionary discipline for students who are under 8 years of age and to school district truancy referrals to the state's attorneys, introduced by Senator Rahm. Please listen to the first reading.
S84, an act relating to the use of exclusionary discipline for students who are under 8 years of age and to school district truancy referrals to the state's attorneys.
You've heard the first reading, and the bill is referred to the Committee on Education. And finally, S85, an act relating to designating certain sheriff's deputies as classified state employees, introduced by Senators Hooker, McCormick, Perchlik, and Polina. Please listen to the first reading.
S85, an act relating to designating certain sheriff's deputies as classified state employees.
You've heard the first reading, and the bill is referred to the Committee on Government Operations. This brings us to the orders of the day. We have on the calendar for action S18, introduced on January 13, 2021. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as appears on pages 119 to 121 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of the bill.
S18, an act relating to limiting earned good time sentence reductions for offenders convicted of certain crimes.
The chairman of the Senate Judiciary Committee, the senator from Bennington, is recognized for the report of the Committee on Judiciary.
Thank you, Madam President. You start off with a few comments. S18 proposes several modifications to the Department of Corrections Earned Good Time program that the legislature reinstated in 2019 and adjusted again last year as part of Justice Reinvestment 2 legislation. Earned Good Time permits an inmate to earn reductions in his or her sentence if the inmate behaves well and does not commit any major disciplinary violations while the inmate is under the Department of Corrections supervision. Vermont actually did have a system of statutory good time for nearly 40 years until it was repealed in 2005. In 2018, a report by the Department of Corrections recommended reestablishment of the Earned Good Time program, and the legislature agreed on the basis of empirical studies showing that Earned Good Time is effective at prison population management, has little to no community impact or effect on public safety, and is perceived by correctional administrators as having a positive impact on facility control, and it reduces incarceration costs. As a result, the legislature reinstated the Earned Good Time program in Act 56 of 2019. Rather than specify in statute all the required details of the Good Time program, the legislature set out guidelines and requirements and directed the Department of Corrections to implement the program by rule. The rules went into effect on January 1st, 2021, and inmates have been eligible to earn time since then. Under current law, the program must be available for all offenders under DOC supervision, regardless of the offense, except for offenders sentenced to life without parole. For each month that an offender is not adjudicated of a major disciplinary violation and is not reincarcerated for a violation of condition of release while on furlough, the offender earns a reduction of 7 days off his or her minimum and maximum sentence. This does not mean, and I emphasize this, that the inmate will necessarily be released when the minimum sentence is served. It just means that the inmate is eligible to appear before the parole board sooner and be eligible for early release if the parole board approves. At this point, a word on terminology is necessary. While originally referred to as Earned Good Time, the Judiciary Committee this year heard testimony that such a name is not necessarily appropriate. An offender qualifies for this program by not committing disciplinary violations while under DOC supervision. This does not necessarily mean that the offender was good or not good. It just means the offender earned a sentence reduction by not engaging in conduct that the Department of Corrections views as a major disciplinary violation. For this reason, the committee concluded that earned time is a more accurate name for the program, and you will see that S18 renames it to the Earned Time Program throughout the bill. The substance of S18 arises out of an unforeseen consequence of the program that was enacted. Thomas J. Donovan, Attorney General of the state of Vermont, was our first witness. And he said, and and I'm paraphrasing now, we made a huge mistake. We being the legislature, all of the groups who supported the bill in 2019 and again in 2020, that one of the things we didn't take into effect was those offenders sentenced for very serious crimes 10, 15, or 20 years ago would now be eligible to start accumulating earned time on January 1st. Most of these cases were resolved with plea bargains that the victim agreed to on the basis of the state's attorney's explanation of how much time the defendant would serve in jail. If these offenders get earned time now, essentially changes the terms of that sentence that the victim agreed to, and it's understandable that many victims of serious crimes are quite upset about this. Your committee heard from a number of victims and representatives of the victims' community. It's worth noting that the Center for Crime Victim Services, when we passed the bill, was in support of the bill originally. And they recognized that they too had made an error, but were concerned about how the notification would take place. If I might, Madam President, I'd like to read an article from the Burlington Free Press, July 1, 2007.
You may.
Thank you. A local man admitted yesterday that he kidnapped, raped, beat, and strangled Laura Winterbottom, 31, more than 2 years ago, resolving a case that shattered a community that believed it had been immune from such violent, random crime. Gerald Montgomery, 35, agreed to plead guilty and served 43 years to life in prison in exchange for a
Point of order, Madam President.
What is the point of order?
There is a senator who is not muted, and we have distractions.
It seems as if there was a phone ringing in the background of one of the senators'
Actually,
homes.
my phone, Madam President, and I couldn't answer the phone because I was reading the letter.
Thank you, Madam President.
Senator, you may continue, and with regrets for disrupting your report.
I apologize that I disrupted my own report by not answering the phone. Such is life on Zoom, Madam President. Montgomery agreed to plead guilty and serve 43 years to life in prison in exchange for a promise by prosecutors not to seek an aggravated murder charge, which carries an automatic sentence of life without parole. Madam President, it's a more extensive article, but I don't think I need to read any further. I think we all probably remember that case as one of the most horrific cases in the state's history. Your Committee on Judiciary did hear from the Winterbottom family, Joanne Winterbottom and Ned Winterbottom. They talked about how they felt in agreeing to this sentence to avoid a trial with a lot of personal information might come out, a lot of other information, and they agreed to that. That was part of their understanding of the sentence, and they were very upset that the legislature and the administration, as well as so many others, had passed a law that changed that sentence. We also heard from a young victim, a young lady who was a victim as a child of Robert Klobach, and they relied on his sentence so that she could avoid. She was 13 years old, and they relied on that sentence so she could avoid going through the trauma of reliving her victimization over again. So I think it's important to recognize that this bill is a result of those types of cases. There are numerous cases around the state, luckily not many, Madam President, but there are some. So S18 addresses this problem by prohibiting certain serious offenders who are already incarcerated from participating in the Earned Time program. Future offenders will be able to participate because, contrary to past offenders who are already sentenced, in future cases, the victims will have been notified that the Earned program exists, and the victims will have input into proper sentence with that information in mind. Turning to the language in the bill itself, Section 1 requires the victim notification that I just mentioned. At or before the sentencing hearing, the prosecutor must inform the victim of the maximum amount of earned time that the defendant could accrue, and that earned time affects when the defendant is first eligible to be considered for release on parole by the parole board, but does not necessarily result in the defendant's release. Section 2 changes the name of the program to the Earned Time Program, and as I mentioned, at the request of the Department of Corrections, it also clarifies that it is not available to offenders serving interrupted sentence. An interrupted sentence is defined as a sentence that is not served continuously. This includes sentences to be served such as weekends or sentences to a work group. The Department of Corrections explained that these sentences are brief and intermittently served, so they do not make sense for earned time to apply. Section 2 limits the earned time program so that it does not apply to offenders who are already sentenced for what is called a disqualifying offense. They are defined to be murder, voluntary manslaughter, kidnapping, sexual assault, aggravated sexual assault, and aggravated sexual assault of a child, or lewd and lascivious conduct with a child unless the offense fits an age group gap where the offender is under 18, the victim is at least 12, and the conduct is consensual. This age gap already exists in current law and is repeated here to ensure voluntary consensual conduct between young people is not criminalized. And so that basically, those folks who might be sentenced for that would be eligible for finally, it should be noted that under Section 1 of 1 VSA Section 214, new legislation generally applies prospectively into the future and not retroactively to past conduct. Since S18 does apply retroactively to defendants who have already been sentenced, the bill includes a notwithstanding clause that permits such an application. This is standard language used when we pass legislation to apply retroactively. It is, of course, it's still possible that the Defender General will challenge the bill's constitutionality. The Attorney General believes the courts will uphold this bill, and the Senate Judiciary Committee, by the way, the bill takes effect on passage. The Senate Judiciary Committee urges the adoption of this bill, and the voting committee was 4-1-0. Thank you, Madam President.
Thank you, Senator. The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? The senator from Addison is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill, please?
You may.
Thank you. Senator, this past year, I believe almost a year ago, we passed the Justice Reinvestment Act 2 in this body, and your committee did a lot of really fabulous work on that. And my recollection is that part of that was there were supposed to be savings in our correctional budget in order to reinvest them back into community programs. So my question is, did your committee look into the fiscal impact on this bill, and would it impact our state's ability to move forward with those reinvestments in any significant way?
The answer to your question, Madam President, is we did not look at the fiscal impact. It is a relatively small number. We do not believe, the majority of the committee does not believe that this bill will undermine our overall goal of justice reinvestment and moving Vermont prisoners out of Mississippi and back into the community. Actually, Madam President, we have seen a reduction down to 184 offenders held out of state right now, and the numbers continue to be lower. We hope that continues. If we had continued with this and not made folks who are sentenced in the future after passage of the bill eligible for earned time, then I think we would have had significant significant impact on the numbers. But I don't think, given the relatively small numbers, it will have a huge impact.
Okay. Thank you, Madam President. That's very helpful. Thank you.
The senator from Chittenden is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill?
You may.
I'm sorry I didn't look at this a little closer beforehand, but I'm just unclear as to whether this applies, this expansion or the reduction or disallowance of good time to certain prisoner applies to people who are already in prison, who have been sentenced. Does it also apply to prospective individuals who commit these horrific crimes going into the future?
Mr. President, Madam President, the bill is not prospective, so it only applies to a group who were sentenced prior to the effective date of the bill and who are who would not be eligible. In the future, the committee decided to make prospectively folks eligible because there will be the opportunity for victims to have input on the plea bargaining. 99% of the cases in Vermont are plea bargained, as you may know, and therefore the victims would have impact, would be aware. And unfortunately, the victims were not aware of this change in sentencing and did not have a voice.
Thank you, Mr. President. That was the answer I was hoping for.
Retroactive.
Thank you, Mr. President. That was the answer I was hoping for. I just couldn't find it in reading it. Thank you very much.
Thank you. The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? If so, please unmute. All those in favor signify by saying aye.
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 Those opposed, nay.
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 The ayes appear to have it, and you've amended the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read the third time? Are you ready for the question? So please unmute. All those in favor signify by saying aye.
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 Those opposed, nay.
Nay. Nay.
The ayes appear to have it, and we've ordered a third reading of S18. This completes the orders of the day. The senator from Windham is recognized.
Thank you, Madam President. Pending announcements, I move that the Senate stand in adjournment until 1 p.m. Thursday, February 18th. If I might, Madam President, I'm going to ask that senators hold their announcements today until we are done with our presentation from Dr. Levine, as he is already waiting to join us, so we can take announcements at that time. Thank you, Madam President.
Thank you. Is that a motion to hold announcements?
Short recess?
Recess, perhaps? Just say. We will quickly go through announcements. Senators, are there any announcements before we take up the motion to adjourn? Okay, seeing none, hearing none, the senator from Wyndham has moved that the Senate adjourn until Thursday, February 18th at 1 p.m. Are you ready for the question? And if so, please unmute. All those in favor signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and the Senate stands adjourned until Thursday, February 18 at 1 p.m.